such a long time. If you can hear me, please give me a one in the chat so I know that you can hear me. It's been so long, y'all, that I had to remind myself how to use StreamYard. So I really need your help. I had to go through a whole little tutorial like, how do I go live again? How do I do this? What? My bad on it being so long. But y'all, I really want you to know that I've appreciated your texts, your emails, your hey, where you been? You all right? I'm good, y'all. I'm good, Life is good, just busy. So I'm so sorry I've been gone so long. You all really are like a family to me. I love you. I care about you. And I'm really hoping this summer to carve out some time, not weekly, I can't promise that, but to carve out some time bi weekly to be with you. So I am working on that. So, anyway, hello. Welcome back to another installment of Empowered Esquire TV, where I empower you with the law and where we have edifying legal conversations. All right. So, here we're going to do the disclaimers because we got to do the disclaimers. This is a community of respect and compassion. Please do not disrespect anyone in the chat. Do not disrespect anyone in the chat. Please be kind to each other. Please refrain from profanity and disrespect. Okay. And now, my personal disclaimer, all right? I am a lawyer, but I am the president of the Lawyers Have Lives Coalition, okay? I have a life. I'm a person and I have a personality. This is not court. This is not a courtroom, right? So when I come into this space, this is a space where I'm having a conversation and I may show some personality, all right? That's allowed. By the way, there are attorneys on YouTube that drink in their videos, curse in their videos. Okay, so if me having a little bit of sass is too much for you, baby, this ain't for you. Okay. Let me hop in the chat and say hello to all the folks. Hello, Pretoria Afro. She gets the award for first person to be in the chat. So what's up? Hey, Shaka. Hey, Shafreen. Hey, Empress Kaya, one of the people who reached out and checked on me. Love you. Hey, Trip C. What's up? Doug, the world's most requested moderator. Also, someone else who reached out to me. Hey, Chief. Let's see. Hey, Jay Haru. Royalty. Shinoa or Shinwa? No, Shinoa. Shinoa? I'm going to go with Shinoa. Let's see. Top rated. Oh my goodness, my favorite YouTube name is here, y'all. A bit tad. I have to put this up on the screen. Y'all, this is my favorite YouTube handle. Oh my goodness. Claymore Jones, Nagus Roselle, Haru Kanzu, Miss Tiffany, Born Eternal. All right. I think I got around to everyone. So you guys know I'm not for the long intros. Let's jump right in. Today will be a call-in show. So towards the end of the show, you'll be free to call in, come up, and discuss how you feel. Alrighty, so listen. This Michael Nowak, aka Brother Polight case, has been ongoing for quite some time. Okay, there have been quite a few court appearances, but thus far, nothing much has happened by way of the case coming to any resolution, right? We have not seen a trial, and we haven't really seen the setting of a solid trial date per se. Now, what has been said is that Brother Polight, I say that with air quotes, is set to plead guilty, right? That is what is being said. Now, for those of you who maybe you're like me and you honestly weren't paying that much attention and you might be behind, okay, allow me to catch you up a bit. So what I'm going to do right now is read from the screenshot that I have of the docket, the most recent goings on in the docket. Am I going to show you the screenshot? No. And here's why. There are 50 million amazing, credible people who have already shown you how to track Brother Polight's case online, and how to look at the docket. I believe Let Me See Your Transcript has done that, and I know for sure that Queen's Throne has done that. Okay, you can go on to either space. We're not going to reinvent the wheel. Okay. So as of July 7th, it was put into the docket that there was a plea set for September 6th, 2023. Okay. Then on July 10th, it was put into the docket that a trial prosecutor has been assigned. Now, for many people, those two things put together are a bit confusing, right? Because first, you see that allegedly this is set for some plea agreement or some plea deal, right? But then, second, you see that a trial prosecutor has been assigned. So let's take it step by step. Let's start with July 7th and the conversation surrounding plea deals and plea agreements. Okay. So a lot of people online have been saying, well, he's going to get this amount of time in prison, or this amount of time in prison based upon his plea deal or plea agreement. No one can say that, because no one, unless they have the paperwork, which I highly doubt, right? They cannot say that. Okay, let me give you the rundown on how the plea agreement process works. It is a negotiation between defense counsel and the government. Defense counsel and the government discuss, negotiate, and come up with what is called a plea agreement, right? In that agreement, it is denoted what the defendant will actually plead guilty to, what the potential or recommended sentence is for that plea, and then any other additional implications, right? A plea agreement has not been completed until the defendant pleads guilty. One more time. A plea agreement has not been completed until the defendant goes on the record, changes their initial plea, that initial plea in which they pled innocent, which Michael Nowak did initially, right? Changes that initial plea to guilty. At that time, Michael Nowak will say he's changing his initial plea of not guilty to guilty. He will then state what he is pleading guilty to. Why is it important for me to tell you that? Here's why. When you negotiate, there is give and take. In a large plethora of plea deals, you do not see the defendant pleading guilty to the top charge or the highest charge in the charging document, because it is, again, a negotiation, right? And in any negotiation, why would the person agree to the worst possible outcome? So understand that it is very likely, right? And this is just educated conversation, not speculation. But understand that it is very likely that, quote unquote, Brother Polight will not be pleading guilty to the top charge in the charging document. So those online who are speculating that he is going to receive the maximum amount of time possible under all of the charges on the charging document, they're dragging it. Okay. It's called a plea negotiation and it's called a plea agreement, right? That is how that works. So let's take a slight walk down memory lane. Let's take a look at the Brother Polight playlist here on this channel, because I want to play the very first video we've ever did on this case. The reason being is I want us to look at the initial charges, right? Talk about what those were so that we can actually talk about the potential outcomes for this plea agreement, as opposed to pretending like we know what could happen. Okay. So now, a brief pause before we do that. Remember, I said that on July 10th, there's this entry in the docket that says trial prosecutor assigned, right? Now, some people haven't been up in arms about that. And they've been saying, well, what does that mean? Does that mean that it's going to trial now and that there's no longer a plea agreement, or what is going to happen, or blah, blah, blah. Okay. Let's all calm down. Let me have a conversation with you about that. So you know that we like to keep it balanced and as intelligent as we can here, right? So we don't want to jump to conclusions. So there are a number of things that could be happening here. First, the original trial prosecutor assigned may have some reason why he or she can no longer remain on the case. Maybe they left the office, maybe they've fallen ill, etc., etc. Okay? That's the first outcome. The second outcome is that perhaps the government wants to be prepared in the instance that the plea agreement does not go through. Because as we discussed, it's not over till it's over, right? It's not over until Michael Nowak gets on the record and pleads guilty. So, first possibility, perhaps the original trial prosecutor can no longer remain on the case. Second possibility, perhaps the people are preparing themselves for the possibility of a trial because it is not over until it's over. And let me add for you one more note on plea agreements. They do still require the approval of the judge. So, yes, the government and defense come together and they have this quote unquote agreement, but the judge still has to approve this agreement. It doesn't happen very often that judges reject these agreements, but they do. It has happened, right? So you may just be seeing the government preparing themselves for anything that could happen. Let me hop in the chat. Shaka Ndugu says, let me put this up. How do we know he pled guilty in the first place? So we don't, Shaka. We don't know that he has pled guilty. The docket report says that it is set for a plea. And from that, right, we are saying that according to the docket report, he is set to enter some sort of plea based upon a plea agreement. But again, that may not happen, right? Let's see. Any other comments? Jelly with the Hanafuda earring says, this would be the third prosecutor on this case, I believe. Maybe. Okay, so let's have a conversation about that very briefly. Is it quote unquote normal for a case such as this to have landed on multiple desks? Here's what I will say. Yes, I will say it's not that outside of the norm for this case to have been shifted from one prosecutor to the next. These types of cases may initially land on the desk of someone who does not have as much experience for them to handle the legwork of this case. And then once the case progresses and gets into more of a trial posture, it may very well then be handed off to someone with a bit more trial experience. So we're not totally out of the norm yet. All right. Hit the like if you haven't already. I agree. Only because with all the foolishness out there, we need to get the intelligent conversation out there as well. All right. Someone wants me to speak on the amended charges. We could get there, but I want to focus on discussing plea deal, plea agreement, and outcomes. All right. MJ has a question. He's waiting on a better judge. I don't believe the judge has shifted that often, right? And a quote unquote better judge isn't really an outcome here, right? Because when judges review whether or not to accept plea agreements, they're looking at a few things. First, they're looking at, is the plea agreement quote unquote fair, right? So is it an agreement that for the crime charged and for the crime pled to, it is a fair outcome? They're also looking at whether or not the defendant understands the implications of the plea agreement. I have seen plea agreements not go through because it was clear to the judge that the defendant did not truly understand, and they are not going to accept that. And then the third being, the defendant has to earnestly enter the plea of guilty. So if you have a defendant who gets on the record and says, oh, I'm saying guilty, but only because, I want to get out in time for Christmas, the judge will more than likely not accept that, right? Because In all three instances, that plea can be overturned by saying that the defendant's constitutional rights were violated, right? Your constitutional rights are violated if you are bamboozled into saying that you are guilty of something you aren't actually guilty of. All right. A bit Tad says, I was in my conspiracy theory bag, like he done bought the judge off. Oh my goodness, you always have the funniest comments. Oh, okay. So Shaka meant innocent instead of guilty. So yes, in his initial plea, he said not guilty. And at his arraignment, he entered a plea of not guilty. So here's the thing, Shaka. If you enter a plea of guilty at your arraignment, then your case moves forward towards sentencing. You have said you are guilty. The only way that your case enters adversarial position is if you say at your arraignment that you are not guilty, as Michael, quote unquote, brother Polight Nowak did. Okay. B Legend has a question. What's the difference between guilty and no contest? That is a good question. So when a person says that they are guilty, they are saying, I have in fact committed whatever offense I am accused of. Now, when a person says no contest, they are saying, I am not saying that I committed these offenses, but I am acknowledging that there's evidence against me and I would like to dispose of this case, right? So guilty is, I did this. No contest is, I didn't do it. I'm not saying I did it, but I know there's evidence against me. So they're legally different. Levon says, with the evidence that's already in play, do you think it's likely that Mr. Nowak won't see actual jail time? Well, here's the thing, Levon. The quote unquote evidence that's in play, because remember, we have not had a trial. And this is what I want all of us to garner today. What an attorney says is not evidence. So all we've heard thus far is attorneys get on the record and say things. That is not evidence. We have not had a trial where we've actually seen evidence presented. So that's my answer to that question. Claymore Jones question. Is it likely that the plea agreement involves at least one of the felonies because the prosecutor said it will require incarceration? Well, Claymore Jones, that is a possibility, right? And that's something we're going to get into next because some of the charges would require SO registry. You guys know what SO is, right? And you know what the SOR is? Okay. Some of these charges would require SO registry. And I have to say that in the beginning of this case, Michael Nowak, aka Brother Polight, he was so adamant about his innocence at the beginning of this case. And so it's interesting to me to consider the possibility that he may enter a plea which would require SO status, that he would agree to plead guilty to being on the SO registry. That's an interesting premise for me, considering how adamant he was about his innocence in the beginning. T. Ben's question. So is there any possibility that he walks free? Well, is there? Well, here's the thing. A lot of things are possible, right? I mean, let's be real. Almost anything is possible. But if he pleads guilty, it is not extremely likely that he would walk free. And there's a reason for that. So the reason being is that when you consider the charges against him and the minimums attached to those charges, which again, we're going to discuss as we revamp in the next video, right? It's not very, very likely that he would walk free. He did not serve that much time in the beginning, right? If you guys remember, he was not incarcerated that long before he got released. Now, allegedly, he was released on clerical error. The long and short of it is that he was released, which means whatever sentence he ends up actually receiving, he doesn't really have much time to go towards that sentence. He doesn't have days upon months of time served. So The possibility that he would actually walk completely free is not extremely likely. Quizmatics. I heard Polight skipped his last court date, the one he was supposed to agree to the plea. Is that true, or is there a new twist to this story? So there's very minimal audio of that last hearing. Uh-oh. You guys know, if you're OG here, you know that Mac cannot let us have a live in which he doesn't make himself known. So you might hear him. So yes. So in the last hearing, the audio was very minimal, but I believe we did hear Michael Nowak respond to the judge at the last hearing. So whether he was there in person or there virtually, we don't know, but he was there, right? And the judge did allegedly set the case for September 6th for the receipt of some sort of plea. All righty, let's see. I am my grandmother's rebellion. I like that name. I like that handle. All right. Hello. Let me see if there are any other questions before we move on. I don't see any other questions. All right. I think someone said something I want to share with you. All right. So, little YouTuber said maybe he's pleading guilty so he won't be put on SOR. And that, everyone, is possible. I wanted to sing like how they sung in the Black Cinderella, that possible song, but it didn't work. So that is totally possible. It is possible that the parties have reached some agreement which would keep Michael Nowak, aka Brother Polight, off of the SOR. That would make sense, right? I would think if you're going to enter a plea, it might be important to you that you stay off SOR. It is a negotiation. You never know. All right. Let me get into showing you all. Share screen. If you're OG here, you know I always announce that I'm sharing my screen. Why? I don't know. Right. So here we are. Now you can see the playlist here. This is the Brother Polight playlist. Okay. And it has every video that I have ever done on this case. It is available here on the channel. Now, let's go to the very, very first video. I think it would be this one, right? Case update, court hearing. This would be it. Oh, wow, look, it was featuring Chief X. That's so cool. Let's click it. Okay, wonderful. We should be able to hear the audio, but we don't need that right away. We're actually going to skip through quite a bit. We want to go into the breakdown of the charges. We want to get there. Where is that? I know we did a breakdown of the charges in this video, didn't we? I don't even see. Oh, this is the wrong one. No wonder. I'm there like, this doesn't seem right. I don't even see Chief X here. All right, here we go. Let's start about here. And I'm going to mute me so you don't hear me again. Of the courts, right? Criminal justice online system. You see all this information in the beginning. You see Michael Nowak. You see the date this case was initiated, right? All this stuff that lets you know you're looking at the case that you're actually trying to look for. Okay. So let's go past charges for a moment and let's just go here to docket, right? This is the docket report. So you can start from the very beginning here, August 17th. August 17th, you see a charging document was filed, right? And so an arraignment hearing was scheduled for September 15th. They have that it was assigned to the intake unit for these certain types of crimes, right? They have that a prosecutor was assigned by the name of Nicole Garcia, right? And then they also have that a Mr. Adam Rosen, Esquire, was given a notice of the hearing as he is the defense attorney of record in this case. August 18th, demand for. So one thing I wanted to note, I've unmuted myself just to note this, right? Remember when we said it's not extremely likely that he just walks free because he did not serve that much time to begin with. He does not have that much time served. Okay, check out the docket. August 17th was arraignment. By August 18th, he had already received bond. So, again, to go to our previous conversation, it is not extremely likely because he does not have a lot of time served banked. Even for a misdemeanor, he would more than likely still have time to serve. Discovery, probably filed by Mr. Rosen or Rossen, right? Because it is commonplace for a criminal defense attorney to file a motion to dismiss, as you see here, and a demand for discovery right away. Sometimes that is referred to as an omnibus motion, right? It's an all encompassing motion. But it is commonplace for the minute a defense attorney is retained, they say, all right, let me file my demands. Let me file my motion to dismiss. Now, here's the thing. Do they think that the case will actually be dismissed? Maybe not. But to protect themselves from malpractice, it is commonplace for every criminal defense attorney to file a motion to dismiss. Because even if they don't think they can, the charges now. Fast forwarding a bit to get to the charges. Okay, so we're going back to our same page here. See, the docket report is down here. Now, if you scroll up, you see the charges. Now, I'm going to start from the portion of this that I know all of you are just absolutely dying to hear me clarify, right? I already know. So let's start from that portion, shall we? Down here at the bottom, you see the two felonies that were initially charged along with this misdemeanor. And here you see. So let's talk about this briefly. As you can see, the lowest charge here is contributing to the delinquency of a minor. To my knowledge, that is still the lowest charge. Okay, that is still the lowest charge, and that is a misdemeanor. But as we just discussed, he does not have any time served. What, a day or so? So even if hypothetically the plea agreement is the misdemeanor, he would probably still, very likely still, educated guess, have time to serve. Okay, he would probably still, very likely still have time to serve. See no action as the disposition. So people, no action is legally different from an outright dismissal. Let me explain what no action means when you're talking about a felony. So, no action means that no further information was filed on those charges. To see me in chief. Let's see. Forward. That doesn't make much of a difference. You can still look at us. All righty. So here we go in our. Okay, so I'm going to hop into the chat to answer any questions before we dive into this portion where we actually look at potential time and talk about potential plea arrangements. Plea arrangements, plea deals. You get what I'm saying, right? Once more, the lowest charge is a misdemeanor. So if he were to plead guilty to the lowest charge, he would plead guilty to a misdemeanor, okay? And contributing to the delinquency of a minor does not put you on the SOR. So if the goal or the concern was to stay off of the SOR, the lowest charge would be the plea agreement. But remember, this is a negotiation. So it depends on the strength of the government's case. If the government has a particularly strong case, they more than likely would not agree to him pleading guilty to the lowest charge. Because more than likely, they would say, well, if we can prove a higher charge at trial, why would we agree to you pleading guilty to a lower charge? Right? But the higher charges have SO implications. Does that make sense? Does everyone get that? Okay. What is the difference? Well, we're going to get into it here. Okay. But when a defendant pleads guilty to a charge that has a SO implication, not only do you have SO registry, you have what happens after you do your time because SOs are monitored. You have to check in, you have travel limitations. Think Nicki Minaj's husband. You have limitations on where you can live. Okay. All right, so I am in the chat. Let's see. Question from Shaka. What does reset for plea mean? Okay, so in the docket report where it says reset for plea or set for plea, That does insinuate that the case is set for a plea deal or plea agreement to be put into the record. That's the insinuation. But remember what I said, it ain't over till it's over. It's not done until Michael Nowak gets on the record and pleads guilty. Anytime before that, it could fall apart, which is another reason why we have to be very careful about the way that we discuss these cases online, which is another reason why I'm going to continuously ask you all to not come online and create video titles that say like Brother Polight to serve 20 years. You don't know that. Stop doing that, please. Okay. Let's see. Uh-oh. You guys hear Matt? Oh boy. Okay. Uh-oh. Okay, Mac, we're live. All right. So Jelly says, I was reading something about a judge having a sentencing sheet, where there's a point system for calculating how much time a person has to serve. Jelly, that is an amazing, amazing question. So what Jelly is referring to are sentencing guidelines. I'm going to put them in late chat. Sentencing guidelines. Most jurisdictions have them. And for some jurisdictions, they're public. For some jurisdictions, you can literally Google it and pull up the sentencing guidelines. But here's the thing. There's a difference between sentencing guidelines and plea deals or plea agreements. So sentencing guidelines is usually applicable, right? Mostly applicable when the judge is sentencing. But when we're talking about plea deals and plea agreements, it is a conversation between the government and the defendant. The prosecutor may use the sentencing guidelines to help guide them in the plea deal process, right? But plea agreements are a bit different. Okay. Sugar Hayes says, why did the judge ask him to turn in his passport? So when you are facing these types of charges, Sugar Hayes, charges of a serious nature, the court wants to make sure that you do not try to flee, right? And so when you consider that Brother Polight is out and about, he's not incarcerated during this case, it does make sense for the court to ask for his passport to ensure that he does not try to flee the country. All right, let's see. Hi, Michelle Jordan. I miss you too. All right. Let's move forward. Our doc. Let's start from the beginning, shall we? New charges. Okay, so the new charges, the new charges are all lewd and lascivious offenses. Oh, you know what? I wanted to show you Online Sunshine. So, you know what? We'll do it in reverse. We'll walk through this first, and then I'll show you Online Sunshine. How about that? Okay. Alrighty. So this is all pulled from the state of Florida Online Sunshine statutes. Okay, so this is directly from the statutes.
And everyone, no one can pronounce the word except you. Lascivious.
Lascivious. It's lewd and lascivious. If pronouncing words is not your thing, I would recommend doing a lot of reading. I did a lot of reading growing up, and then words just became my thing, right? And another thing you gain with that is languages become your thing too. So yeah, reading is great. It's fundamental. All right, here we go. So lewd and lascivious, a lewd and lascivious offense is when a person intentionally touches a blank, you know, I try to stay away from certain words, under 16 years of age in a lewd or lascivious manner, or solicits a blank under 16 years of age to commit a lewd or lascivious act. Pause. So this means that a person does something intimately inappropriate to a minor or tries to do that via soliciting the minor to do those things. Now, the direct definition of lewd and lascivious is just wicked, lustful, unchaste, licentious, or sensual. That all amounts to intimate, right? The S word that we also don't use on this channel. That's what it all amounts to. Now, these types of charges are strict liability charges. Let's take a moment here, because we just need to have a blank is child, Buddha. It's YouTube, you guys. The video will get taken down if we use certain terms. Let's have a moment here to remember some things. There is still conversation about consent and, why is he being charged? Again, many of these charges are based upon strict liability, which means there is no potential for consent. In many of these charges, it is based upon the other person slash victim being a minor and that minor not being able to consent. Okay. Mind you, that also applies to the parent, because I've heard some people saying that the mother may have granted some sort of consent. Again, none of that is applicable. Okay. Advised him not to contact her. That's what I would imagine, because were my client, that is what I would have done. So perhaps he went against the advice of his attorneys on that. Okay. Some people, some person said, Aku Cromanti said, is it even possible that it was the mother's shirt and scarf? We don't know. You know, I'm reliving this. And before we even go down this path, let's just pause it here. Okay. So we know that L&L is what we're going to call it, is a second-degree felony punishable by up to 15 years in prison. Okay. And as we continue to go through these charges, you will see that the up to 15 years is pretty much the hallmark for the top charges here. Okay. Let's talk about legal terminology. Up to 15 years does not mean 15 years. People, up to 15 years means 15 years max. 15 years max. So again, I've seen some people online like, Brother Polight to do 15 years. How do you know that? Do you have the paperwork? How do you know that? Up to 15 years means the maximum is 15 years. Then remember, plea deals are a what? A negotiation. There's going to be give and take because the person is exchanging their right for a trial. Okay. Now there are multiple counts, right? And the max is 15 on the top charges. And it's 15 each. True that. But it's up to 15, and 15 is the max. Okay, let's continue. So we know there's up to 15 for the lewd and lascivious, right? Let's fast forward. And he would have to continue to do so for the rest of his life. Chief, anything? So I'm backing up a bit here because I want us to discuss SO registry and gain time, as you can see here. The entirety of their prison sentence. So all the other ways in which inmates can gain time, whether it's good behavior or any other rigmarole they can do working for this entity or that entity, those things do not apply to these specific charges. These charges, if convicted, you have to serve day for day. So now something to note about the top charges here. Remember, we talked about again the possibility that he could plead guilty and just walk away. Okay. Well, now we know one of these top charges, what we're calling the L&L, is ineligible for gain time. Okay. So in that instance, he would not even, mind you, he doesn't have that much time served anyway, but he would not be able to apply that. Okay. And we know also that the minimum is 30 months. Okay. So there's a minimum sentence of a little over 2 years. So a little over 2 years is your minimum, 15 years is your maximum. Okay, let's continue. Okay. I see in the chat there is something going on because the government believes that parents
with the mother. I never seen the child with Polight and the mother, but people were asking have information on that. But that's just seems like the normal modus operandi.
we have to stop real quick so we can shout out again. Look here. A Bit Tied is famous. My favorite YouTube handle is famous. Look at this. I love it. Gotta be the best name ever. All righty. So I see a question from someone.
If throughout this they found out that there was some kind of oral copulation, correct?
Yes. So any type of inappropriate conduct with a minor is a crime in every.
I think may need to be addressed.
So I'm taking you back a bit just to remind you of Online Sunshine so that you can use it to look up any, any cases that you want or any statutes that you want.
Because people feel because.
Ooh, hope I didn't butcher that. She says, insofar as someone who is not able to pay their bail or bond. So I'm assuming.
I'm not an expert like you, but I think people's confusion with the sexual battery, I think may need to be addressed because people feel because she wasn't penetrated vaginally or anally, it's not sexual battery. But people forget oral is also included with vaginal and anal penetration. And on the police report, it does say he pulled out his blank and pushed her head towards it. So when we talk about revisiting the old charges, that could be a reason they could revisit it if throughout this they found out that there was some kind of oral copulation, correct?
Yes. So any type of inappropriate conduct with a minor is a crime in every state in the US. And oral contact is still considered to be inappropriate intimate conduct. It doesn't matter if it didn't involve the minor's nether regions. Okay. I do want to address this question here. So, True Colors, why is he still getting bail? Go back to my original videos where I explain bail. Bail has nothing to do with innocence or guilt. Bail has nothing to do with the strength of a case. A person is always assumed innocent until proven guilty. So that in itself should let you know that bail and innocence are not attached. Okay. So you can go back to my first videos and it will explain to you what bail is and how bail works. I have 2 videos. I'll probably turn it into a playlist or something for you, but I have 2 prior videos in my coverage of this case. Okay, so let's go to Online Sunshine, shall we? I have it pulled up here. If you're new here, welcome. This is Online Sunshine. This is how you can view any law, any statute, anything in the state of Florida, right?
And before you get started, I think people need to hit that like button. And if you're not a subscriber, I don't know why you're not subscribed yet.
Since Chief X already did it for me, let me just reiterate. Have you hit the like button? And if you're not a subscriber, have you subscribed yet? Okay. So the purpose of us taking this walk down memory lane is to again discuss the top charges, the quote unquote felonies in the original charging document. Okay. Now, I could be wrong. I could be behind. And when I mean wrong or behind, I mean there could have been some superseding charging documents after this? If so, and if that changed the top charge, feel free to let me know. Okay. But to our knowledge, the top charges in this case have a maximum of 15 years and a minimum of 30 months. Okay? So again, up to 15. Up to 15 does not mean 15. It just means up to 15. Now, is it possible for him to plead guilty to more than one count? That's possible, right? But again, remember, a plea deal is a negotiation. So, very often when you see plea deals, you do not usually see people pleading guilty to multiple counts in one incident. What you're more likely to see is there were multiple incidents, and so that person is pleading guilty regarding each incident. But when you have one incident and we're talking about a negotiation, a plea deal, a plea agreement, it's not extremely likely to see someone agreeing to plead guilty to multiple counts in one incident. Can it happen? Yes. Can it happen if the government has a very strong case? Absolutely. Is it the norm? Not necessarily. Okay. Let's see what else is going on in the chat. I want to see if there are any questions that I can answer. Okay. Oh, this is a good question. So Texas Bama says, why are some people denied bail? Okay, so that could depend on the person's history. A large consideration in bail is whether or not the person is a flight risk. And when the person has an extensive criminal record, they're considered to be more of a risk. It's considered to be more likely that they will abscond or take off, right? Because they already have an alleged history of breaking the law. Looking for questions. Haru Kanzu has an interesting question. He says, is money slowing down the verdict, paying for a good lawyer, etc.? Well, so in this instance, we're not waiting on a verdict, Haru Kanzu, right? Allegedly, a plea agreement being worked on. We are waiting to see if that is true. We're waiting for September 6th to see if the defendant in this case actually pleads guilty and says that he's reached an agreement with the government. All right, I have another good question here. Sat12 says, is it possible the sidebar at the hearing that was made silent for the public on Zoom was actually a plea made by Polight, but they are trying to keep it off of the media? So here's the thing. Is it possible that they want to keep this plea off of social media? That's totally possible, right? But in that instance, that does not allow for the judge or the court to misrepresent what happened. So what would be appropriate in that instance would be for the court to say an agreement and or a private and or a sealed discussion has occurred. That would be fine. And they would not even have to mention what the plea was, largely because the victim in this instance is a minor, right? But to say on the record that the case is set for a plea and that a plea is to happen if one has already happened would be just a blatant misrepresentation. And I highly doubt the court would just blatantly misrepresent, because remember, at the end of the day, the public record in this case has to be accurate. The public record does not have to be all encompassing. So as I said, they can keep certain things private. They conceal certain things, especially when you have a minor involved. But there's a difference between sealing, keeping private, and misrepresenting. So for him to have entered a plea, but for the court to express that they are still waiting for a plea, that would be a misrepresentation. So that is not very likely. SMH is confirming that they take the passport. They sure do. All right. Haru Kanzu had another question. He said, if it goes to trial, would the young person have to show up in court? Well, Haru Kanzu, that depends. So in these types of cases where you have a minor as the victim. I have seen many instances in which the government, the people, the prosecutor, they try to keep the young victim off of the stand, right? And the reason for that is, quite frankly, because this is re traumatizing for a young person. And everyone is concerned about the young person. Everyone wants to try to limit how much damage this has on the adult that person becomes. So I have seen these cases in which they go forward pretty much what is called evidence based. They go forward with DNA and forensic scientists and detectives, and they try to limit how much they put the victim on the stand. It's possible. But I have also seen the opposite, right? I have also seen where you have a case that is heavily reliant on the corroboration and the testimony of the minor victim. And that demands that you put the minor on the stand. So it's very case specific. And also, there's some discretion there for the prosecutor to decide what he or she needs to do to have the strongest case. All right. So first things first, I forgot to say what's up to Nappy Yankee. Nappy Yankee, I did see you in the building. Let me see if I can find you so y'all could show him some love. Oh shoot, it's gone. I can't find you, Nappy, but I did see you, Nappy Yankee. What's up? I see you, Zion Lex TV. What's up? All right. SMH says, I have a question. Why did they cut the live stream? So if you're referring to the hearing, remember the victim in this case is a minor. So there is heightened privacy protection here. Whenever you have, let me give you a little bit of a dissertation, if you will, on privacy. So there are certain types of cases in which the victim has heightened privacy, heightened protection. First, cases that involve minors, and second, cases that involve domestic violence. The reason being is because the person who is the victim is considered to be a part of an especially vulnerable class. So if you're a minor and an adult has allegedly hurt you, you're extremely vulnerable. So you're going to get more protection. If you are a woman or a man in an intimate relationship with someone, so this person knows where you live, they know where you work, they know how to get into your house, right? You're considered to be extremely vulnerable. So you're going to get more privacy, more protection in these cases. So they may have cut the live stream because something was being discussed about the case that the court has decided for the protection of the victim, social media should not hear about. Right. And that's going to happen more often in this case than in any old criminal prosecution. The most requested moderator said hit the like. Let me get the link, you guys, because this is a call-in show. So link is in the chat. Please come on back, ask your questions, chat it up with me. Let's discuss. Let me take this off. All right, we don't need it right now. Okay. Britt has a question. How many times is he able to continue the case? So I love that you asked this question, Britt. By the way, hello, welcome. You're absolutely gorgeous and wonderful. We're happy to have you here. Okay. So a continuance is an agreement. How many of you knew that? Like, how many of you knew that to continue the case, both parties have to agree? So here's an example. If Polight's defense attorney wanted to continue the case, but the people were ready for trial, they could fight that. They could appeal to the judge and say, we are ready for trial. We do not consent to a continuance. And then the judge could decide not to grant the continuance. So more than likely, when you see continuances in criminal cases, it is on consent. It's on both parties agreeing. And this is one of those instances. Quote unquote, Brother Polight is not continuing this case unilaterally. And when you look at the docket report, you can see that. You can see that first the case was in motion status, then the case had further discovery status, then there were further motions, right? So Brother Polight himself has not been extending this case. All righty, so I got two people backstage. I'm going to go ahead and bring them up. And before you all introduce yourselves, I'm going to mute you real quickly just to answer one more question. All right. Question from Zion Lex TV. He says, seeing that jail time was mentioned, based on the public record, is it possible to estimate the expected time served? So, oh, I have some other people I need to bring up. Um, so here's the thing. Could you speculate? Could you estimate? Sure, you could. Would I recommend that? No. You're wondering why would I not recommend that? Think Tasha K. Okay? I would not recommend you try to, play prison time, guess how much time, say that you think Polight is going to have this certain amount of time. I don't recommend it at all because with these cases, you never know what could happen. And if Brother Polight, aka Michael Nowak, does go free, he now can try to hold you legally responsible for going online and saying that he was going to prison. So I wouldn't recommend it. Okay. Let me add everyone else to the stream. Oh, who is that? Someone mute yourself. Who is that? Someone's unmuted. I thought I had everyone muted though. Okay, thank you. I can't tell who that is because on my end, everyone is muted. That's so weird. Okay, so anyway, welcome to the panel, everyone. Quick reminder about our panel rules: no profanity, no meanness, nastiness to anyone whatsoever, no yelling. Okay, long story short is be your best you. Okay, let's start with SMH369. Introduce yourself and tell us what's on your mind.
No, it's Bizzle. I just go by that. It's E Bizzle. I'm from Chicago. My big brother, Chief X, he hit me earlier, told me when I was at the gig. So once I just got to the crib, I just tuned in. I'm a little bit late, but you know what? I wanted to ask you something. And Neo X, she was in the chat. She gave a good question. What if he pleads no contest?
So, as I explained, there is a legal difference between not guilty and no contest, right? So, no contest, in essence, means I am not saying I am guilty, but I acknowledge that there is evidence against me. And so, because I acknowledge that, I'm willing to dispose of this case. That's what no contest means. Now, a no contest plea in this kind of case doesn't happen very often, right? And the reason being is the allegations here, again, involve a minor. And so usually when you have these allegations that involve a minor and the case has gotten this far, it has gotten this far because the government / prosecution believes very strongly in the case. And then along with that comes this concern that they garner a conviction that will have some sort of recompense for the minor victim. And no contest, again, doesn't have the same implication as guilty. So it's not as likely in this kind of case.
I'm sorry, can I speak?
Oh, wait, we're going to go kind of around. So we're going to go to Chief.
Okay.
All right, Neil. So Chief X, please introduce yourself and say what's on your mind. You're muted. I don't know if it's me or you. Should I unmute you? Or?
Yes, I was muted. My bad. Well, anyway, this is Chief X. I'm glad to be on the panel and be able to ask my question and give my opinion on another question. So I appreciate you doing this live stream so we can all be informed from a professional point of view. Empowered Esquire, thank you. So, can you guys hear me?
Yep, we can hear you.
Okay, cool. So, a couple people in the chat came on late, so maybe you can explain to them again why maybe they would enter a prosecutor for trial in the docket. They had that question. I think they came.
Oh, yes. So I'll repeat that answer. So there are a number of things that could be happening here. Here's the first thing. Maybe the previously assigned prosecutor can no longer handle the case. Uh-oh. Matt. He's being so ratchet. Matt, stop.
Peter.
All right, there you go. So, are you
Give him a
done?
bis- give him a cookie.
Hey, come here, come here. Yeah, come sit with me. Come here.
Give him a
Okay, so
chicken bone.
maybe the previously assigned prosecutor can no longer handle the case, right? That's the first option. Or second, maybe the government is preparing to potentially have to go to trial. And maybe in preparation for really having to conduct a trial, they're assigning the case to someone with a little bit more experience. Because again, as I've addressed, when these cases begin, they are sometimes on the desk of someone with a bit less experience and they're just doing the legwork. And when you really get to trial posture, you sometimes see these cases given to someone with a bit more experience. So both of those things are possible. Maybe the person left the office or can't handle the case, or maybe the government wants to be prepared if they really do have to run a trial.
Okay, so here's my question. Okay, and this is like a Hail Mary option. I'm not sure if this is possible or not, but in my opinion, Polite is a narcissist and he will gamble, right? So is it possible? I don't know how this works. Is it possible that September the 6th, Polite can say, you know what? I plead not guilty. I don't want to do a plea, and let's take this thing to trial, right? Second part of the question, because he's cocky enough to do that. I'm thinking. Second part, if they do, if they set a case for trial, that means they have to convene a jury, right? So I'm thinking at that point, there's no more continuances. Am I right? Because that would disrupt convening a jury and seem like it would be some kind of contempt of court type thing. Am I off base with this?
So let's start from your first statement. So, as I said, it ain't over till it's over. So, yes, September 6th could come, and Brother Polite, Michael Nowak, he could say, actually, it's going to be a no for me on the plea deal, and I'd like to take it to trial. That is totally possible. And then, yes, the next step for the court would be to start to impanel a jury and start jury selection and move forward with that. He has the right to a trial, and he can choose to invoke that right. All right, so let's move on in the circle. I think it was actually Neo X next, right? I think so. So introduce yourself and tell us what's on your mind.
Thank you. And again, let me thank you for letting. So my question is, I was originally going to ask what.
You're muffled.
We can't hear you.
I'm sorry. Is that better?
Yes.
Yes.
Okay. I originally was going to ask you the question about the no contest, but thank you for explaining that. But the follow up question to that, let's just say if Polite lawyers work some type of miracle and the plea deal is something similar to a no contest plea, because somebody who, I'm not going to say the person's name, but somebody who we know who's close to Polite has been insinuating that Polite either is going to get off or he's going to get a slap on the wrist with this plea deal. So what's the chances of you if the lawyer can work some type of miracle and it might be a no contest plea?
Okay, so this would be the best case scenario for quote unquote Brother Polite. The best case scenario would be the lowest charge. Remember, that's the contributing to the delinquency of a minor. That doesn't have any SO implications. There is no SO registry. And if he were to be able to plead some sort of no contest to that, that would be a best case scenario for him. And in essence, that would not have much of an implication moving forward. And I don't say that to be mean. I say that again to edify everyone and to be transparent with you, right? Because contributing to the delinquency of a minor could be giving a minor some beer. Let's be real, right? It doesn't have any implication that you did something inappropriate physically or intimately to a minor. Does that answer your question, Neil?
Yeah, I'm close enough because, like I was just saying, I was just curious because the way that the person kind of insinuated, I was like, I think he's going to get a slap on the wrist, and it could be a no contest plea. But I like how you explain that in the extreme case with a minor, it's most likely the prosecutors wouldn't offer a deal like that so he can plead no contest.
By the way, Neil, that guy was lying.
What guy?
The guy, you didn't want to mention his name. He was making stupid.
Oh, yeah, he might be, but you know who I'm talking about, right?
Yes.
Okay, thank you. But thank you for answering the question, sis. I'm gonna go ahead and drop off.
All right, no problem. All righty. So, last but not least, we have Mr. Zion Lex. Please introduce yourself and tell us what's on your mind.
Hey, peace, peace, peace. Can first and foremost, can you hear me clear?
Yes, we can.
Excellent, excellent. So, thank you, number one, for allowing me back on your platform. It's so refreshing to see you back on, commenting on some of the major issues going on in the community. And I'm always grateful for your commentary, your input, and your insight. Having said that, one of the pressing questions that I had as someone who knows Polite personally, who knows the mother of the alleged victim. The mother's name is Linda. Remember, when this thing first played out on the big screen, as it were, I had private conversations with her behind the scene, Linda. So I'm well aware of many things that came out um, later on in the court proceedings, but through speaking with the mom, I had already known many things. Having said that, one of the things that baffled me about this case is, in your professional opinion, why do you think it is that Polite was allowed to be free on the streets prior to arbitration or arbitrary proceedings? Is that normal? Could you kind of explain that for some of us who don't really understand that part?
Absolutely. So, usually with these types of charges, these are serious charges. These are charges of a serious nature, right? It is not the usual nor the norm for someone to be facing this nature of charges and then be given bond as quickly as Polite was given bond, right? It's not that bond is impossible, but like I said, we saw what, a day or two before he was given bond. That was a bit odd, and it has been said that that was some sort of clerical error. It has been insinuated that was some sort of error on the part of the court system, and that's possible. Errors do happen. I hate to give anyone nightmares, but people are released early accidentally all the time. So errors do happen in the court system. And perhaps that was what happened in this instance, because with charges of this nature, to have been granted bond so quickly is not really inside of the norm.
Okay. My last question for the moment, as a follow up to the first question, is are you aware of a statute either making its way to Florida or already passed in Florida where they're looking to give men or women convicted of crimes against children, and especially related to the aforementioned charges, they're looking to give them either life in jail or, worse yet, the death penalty? Has that come to your ears yet?
No, I have not heard of that. But I will say that I have heard, and this was a while ago, that there was a consideration about escalating people with a history of this type
Okay.
of, right?
Okay.
So, as we've discussed here, I talk about this almost every video on this case. Usually, when you're charged with a crime, your past cannot be used against you unless they can argue that you have a pattern of behavior, right? Someone said in the chat, you have a modus operandi. So, what I have heard is a discussion about a law that centers around pattern of behavior and people with a pattern of SO behavior, and using that to escalate the sentences that they are given in new offenses. So, in other words, if you have had two previous SOs and now this is your third SO, it's kind of akin to how they used to have that whole three strikes situation, right? You've had two previous SOs. Now this is your third or fourth SO. You would automatically be on the higher end of sentencing due to it being your third or fourth SO. Now, that's not to say that the system does not already have schematics kind of like that already, right? Because remember, we have the sentencing guidelines, and you're always on the higher end of the guideline when you have a record of any sort. But what I've heard is stricter punishment and guidelines specifically applied to patterns of SO behavior.
Okay, I really do appreciate that. I'm going to go back on mute just to listen, and I surely would like to add some more as the dialogue progresses.
Wonderful. All right. So I see that SMH is still here, Chief is still here, and Naps is here now. So let's
I'm gonna
go.
drop off. I'm gonna drop
Okay,
off.
go ahead, Chief.
I
So
just
let's
have
go to Naps. What's up, Naps? How are you? Introduce yourself and what's on your mind.
Empowered Esquire, what's going down? It's the deal, man. Yeah, what's up, man? Everybody's Naps TV, and what's up to everybody in the panel and in the chat. Um, Here's my question because I just I recently did something on. I want to just juxtapose the two cases in a way, if I'm allowed to here. I recently did something on Mr. Riza Islam. Anyone who's kind of been following that knows that his case was dismissed of, what he was doing. And if you know about the term case dismissed, I did some research before I did the video. Case dismissed doesn't exactly mean you're innocent. All right. And I started to look around and do some research as to what that meant. And one of the things that for a case being dismissed, and correct me if I'm wrong, Empowered, is you can make a deal with the prosecutor for information or something to that effect. Actually, they're short on that, but you can actually make a deal with the prosecutor. All right. So it doesn't mean that you're innocent per se, like he's been saying. My question is this, because Polight seems very he seems very calm for what he's being faced with, and he seems a bit jubilant. All right. Can something happen? And Chief X, I think he kind of alluded to this before, but this is a little different. Can something happen where Polight may have information on a similar case? All right. I'm guessing it has to be in Florida where he can just pull it out and it can give him less time. Like I'm hearing 15 years per charge or what have you. Can he do something where he can pull maybe a Nino Brown, if I may say, and just give them some other cases and get his time drop? Is there something he can do between now and September 6th? Because again, he seems fairly calm for a man who's going to prison for being, a violator.
So to that, and hi as well to you, Nappy. So to that question, I will say this. The situation you've just described is usually more likely in cases that involve narcotics, theft, things like
Mm,
that, right? So
mm,
this defendant is facing, some theft charges that have to do with a ring of persons that were stealing vehicles, right?
mm,
That person could then help the prosecution get to the height of the ring or the top of the chain, and in exchange, they would dismiss their case or give them a really sweet deal in their case, right?
mm,
That type of thing happens all the time, again, in theft cases, in narcotic cases. With this type of case, it does not happen as often.
mm,
Remember, at the heart of this type of case, you have a minor victim and you have
mm,
SO. So when you think about the entire theology and principle behind prosecution, and mind you, not everyone is this purist, but this is what
mm,
it should be, right?
mm.
They are supposed to represent the welfare of the people.
Right.
When you think about cars being stolen or drugs, you represent the welfare of the people if you can get more drugs off the streets in exchange for lowering this person's charges or dismissing the case, right? But now, how does that apply to this kind of case? How do
Right.
you say that you're doing what's best for the people if you exchange this kind of case for information? So it
Mm,
doesn't translate as well. If he were to get some sort of deal in this case, it would more than likely have to be something similar, right? I mean, he would
mm,
have to give them a human trafficking ring
right.
or give them a SO ring or a ring of men that are harming young women.
Mm,
That kind of exchange is where you get to, okay, this feeds the public welfare. But with this kind of case, it's hard to imagine what kind of information he could give them that would help him out.
Well, it's funny because after this happened, and with the conscious community, everybody was being accused of being a violator. everybody was accused. Oh yeah, you did this and you did this. It just started coming out the woodwork. So my that's why I'm saying, who knows? Maybe he may know something, or maybe he is that much of a sociopath where he just doesn't care. Again, he's still out there online. You see him doing the videos and stuff. And I'm like, okay, does this guy? I don't expect. I expect him to show at least a little bit of remorse, or well, not even remorse, just some sort of you know uh just understand what position he's in, where he just keep his mouth shut, but he doesn't. So I don't know. I mean, we'll see. And I do hope, by the way, that you come on more and just get to that whole Riza thing, because I found that to be very interesting. But I will concede to the next person.
Absolutely. So I forgot. Who's SMH again? Bizzle? So Bizzle or Zion, do either of you have anything additional that you'd like to ask or inquire about? Oh, Zion's gone. Bizzle, do you have anything extra that you'd like to add or
Yeah,
inquire about?
you know what? Yeah, before I drop off, I just wanted to ask, if I want to ask you about if he walks, how do you look at him? You know, what do you say if he walks, out of this? What's your thoughts on that?
So let's say this case were to be completely dismissed, because that's the only way he walks at this point, because they haven't had a trial, right? So we're not talking about a not guilty verdict. So you mean if the case was dismissed, or you mean if he gets a deal that means he walks?
Yeah, a deal that means he walks.
So if he gets a deal that means that he walks, well, what do we say to that? Well, we say that there are probably things that happened that we don't know about. There are a lot of things that happen behind the curtain in these cases that we, as the public, are not privy to. And as I have said to some people privately, I will now say publicly, when you have a case with a minor victim, there are 5011, and I do mean 5011 things that could go wrong. Minor victims are delicate. There are so many things that could go wrong.
You know what, the other thing, one more thing, sister, I wanted to ask you about is when they pull the passport. What's your thoughts on the passport?
That's run of the mill. That's totally run of the mill to take the passport when there are serious charges and serious jail time on the table, just to make sure the person doesn't try to flee, especially if the person is the kind of personality that Polite portrays, because he does a lot of flexing online where he talks about traveling to this country and traveling to that country. So, of course, logic would tell you take the passport.
I will say this. I just want to say that regarding the prosecution and making a deal in a case like this, you're right in that a lot of these prosecutors they do have some political aspirations. So if something like this were to pop up, like some of their past cases, and they find out that you made a deal to put a chomo back in the street, then that could actually, that can hurt your chances tremendously. Like somebody like what's the name, Oliver North, who can do what he did but still run for governor in a close race. People kind of forget about that and forget about the damage that he did. But it's something like this, even if it's one child, all right, it can, and you're in Florida, and the child, from what I understand, is Hispanic, and that's something that's a little bit different. So I do understand from that standpoint where you're coming from.
Right. So as I've said, several times, this is the kind of case that everyone is watching you, and the government does not want to have the implication of being light on someone in this instance. So if you see something that appears strange happen with this plea deal next, you'll know that more than likely there's something that we're not privy to. And that happens where we are not going to know everything. So, are there any more questions from Bizzle or Naps? Otherwise, I'm going to hop into the chat and answer some chat questions.
Yeah,
Now,
I'm gonna jump down and peace to the brother. But I was gonna ask the sister, has she got in contact with have you got in contact with Sakari and Gorilla Hebrew? because they was in the court. They was in the courthouse.
Oh wow, no, I have not been in contact with them, but that's interesting. They went to court.
So was
Yeah,
Tony the closer.
yeah, Tony Clo. Yep, he was in there
Yeah.
too. Yep.
Yeah.
Sakari and Gorilla Hebrew. If you get a chance, I ain't on social media. I don't do all that. But if you get a chance, talk to Sakari and Gorilla Hebrew. They was in the courthouse.
Yeah.
Hmm. Interesting. Okay. I mean, if anyone has a line of connection with them and then would like to connect us, we may do another live where we bring them on. So if anybody listening has a line of communication with Tony the Closer or Gorilla Hebrew and wants to make that intro, you're welcome to.
Yeah.
My contact information is usually in the description. It may not be in this one. I might have been slipping because it's been a while. So let me put my email in the chat. My email is my name at gmail.com. And Nappy Yankee knows how to reach me too.
Yes, I do. And let me just say too, um, to everybody, all the content creators and everything, as we're talking about a guy who's going to jail. I'm actually in jail right now, YouTube jail. So I just want to send a warning out to just look through all of your past videos and stuff and scrub them because I'm actually there for something I put out 2 years ago. So yeah, just be careful on these YouTube streets because yeah, they're trying to knock stuff down. So just be very, to all the content creators and everything. Reason why we use the words the way we do, you'd be surprised with YouTube, man. So be careful with that. And I'm gonna step down. Thanks everybody. Thank you, Empower, for having me up. And I do look forward to more material from you and everybody in the chat. Peace.
Peace, Snappy. And this is why I'm so careful, y'all. This is why I use other words. And you guys are like, what does blank mean? This is why we do that, right? Because we don't want to end up in YouTube jail. All right.
But let me ask you this, sis, before I jump down. What's your email again?
It's in the chat, and I just sent it to you message as well in the other chat. You know which other chat.
Oh, okay. I see. Okay,
All
I see.
righty. So we have a question here from Global Warming. Global Warming says, can Aminette be charged with aiding Polight in the grooming process because she was there every step of the way? So remember, it is not what we think, right? It is what can be proven. In a court of law, it's about what you can prove. So to try to charge Aminette here, first of all, you wouldn't be able to charge her with any of the SO charges, right? You would have to charge her with perhaps contributing to the delinquency. And then you would have to provide actual evidence, communications between Aminette and the alleged victim, communications between Aminette and quote unquote Polight that prove that somehow Aminette facilitated something inappropriate. You would have to prove it. And quite frankly, her just being around doesn't prove that. All right, bringing up to the panel, Shanoa. I hope I said it right.
Yes. Can you hear me?
Yes, we can hear you.
How you doing? I had to turn off the show, so I had to close one of my windows. But I wanted to. There was a gentleman who was asking why Brother Polight seems to be so, just cavalier and nonchalant about the situation. And what I'm saying is alleged. Okay, so I'm not gonna like assert that this is 100% happening, but it's alleged that he is a scammer. You understand what I'm saying? So, in order for him to continue to allegedly scam and do the things that he's accused of doing, he has to give the appearance of course, being innocent. And, just act like nothing is wrong, nothing is happening. If he were to show that he was even a little bit scared, people are not going to continue to give him money for give him money for the things that he's alleged to be doing, the scams that he's, alleged to, be carrying out. So that's the reason why he's acting the way he's acting. If I had to, guess, I think he's extremely concerned with what's happening. There was a whole thing going on with whether or not he had pled guilty to anything, or whether he had made a plea and stuff like that. And he hasn't technically pled guilty, but this sort of thing is in the works. It hasn't happened yet. It's in the works. So he went online and he was like, oh, I didn't do this, I didn't do that and stuff like that. But he's not being completely truthful. This plea deal is in the works. It hasn't gone through yet, but it's in the works. So just wanted to kind of just throw that out there. And kind of answer the other gentleman's question.
Yes, thank you. Thank you for your commentary. And did you have any questions or?
Oh my gosh, I had a few questions and now I can't think of anything. Of course, I can't think of anything at all. But you know what I would like you to do? I don't know if you did any videos. This is unrelated, and someone else brought up the Riza Islam situation. Did you do any videos about that? Is there something else that I can go and look at about the Riza Islam situation that you did?
So by the time I got around to his case, I heard it was dismissed.
Okay. Okay.
Even
okay.
Still go there, so I don't know if I'm still going to go there.
Yeah.
Case is still a possibility for me because so many people wanted to talk about that.
Yeah.
I have to decide where I kind of want to go. I would love to expand the platform, right? Like I would love to talk about the Girardis. I would love to, and so my concern, and again, this is in like total transparency because welcome, by the way. We have like open conversations like this here where I talk about concerns. My concern is that I've built a platform thus far. Mind you, it's not as though it's huge, right? But I built a platform thus far that is very niche, and I don't want it to be that,
Right.
So I'd love to expand into talking about the Girardis. Do you know who the Girardis are?
No.
So
now you've piqued my interest now, and I want to know who this is.
There's a much older. He's in his 80s now. White attorney who allegedly stole hundreds of millions of dollars from his clients.
Oh wow.
He was living it up. He was living super lavish in a $34 million mansion. He had private jets. His wife was on Real Housewives of Beverly Hills talking about spending $100,000 per month on hair and makeup. They lived this ridiculous life. And I remember when I first saw his wife on Housewives of Beverly Hills, which I will admit, I watch Housewives of Beverly Hills, but to be fair,
That's okay. Everybody has a little guilty pleasure. It's just fine. That is okay.
It is the only Housewives that I watch.
Okay.
I can't watch any of the other ones. But anyway, so I remember when I first saw her on Housewives of Beverly Hills, I thought, yes, attorneys can make money. True that, but not this much money. You straight up, it is not possible. It is not possible for an attorney just being an attorney to make the amount of money this man would have had to make. Because even if you get a client that has a large settlement, let's say you get a client who has a $30 million settlement, you don't get the $30 million. It's not yours. You get a percentage of that. And the percentage that you get technically goes to your firm. Your firm pays everyone and then pays you. So no matter how you look at it, there's no way this man should have been as rich as he was.
I need to look at that. I would love to know more about that. I would love to know more about that.
So interesting. It's now coming to light that he had a whole Ponzi scheme. So he would take one settlement, steal it, and then when you came to him and said, "Where's my money?" he'd use a newer settlement to give you your money. Really like a Ponzi scheme. But anyway, I like to expand and talk about things like that and not always be in this niche. So we'll see.
Well, we appreciate your work. We appreciate everything you do. I don't get to catch the live every time. I was so happy and excited that I was home, to catch the live. But whatever you make, I definitely go back and, I catch the replay, and you're very, very much appreciated. Thank you so much for explaining, these cases and stuff and doing what you're doing.
Thank you so much to you, Shanoa. I appreciate people like you. This space is my, it's a space where I come and kind of relax, if you will, right? And have intelligent conversation. And it's people like you that make it that way. So thank you.
Oh, my goodness. Thank you so much. You enjoy the rest of your day.
You too.
Okay, dear. Take care. Bye-bye.
Welcome, Texas Bama. Introduce yourself and tell us what's on your mind.
Hello, I'm sorry. I don't know why I can barely hear, but
How are you doing today?
I am wonderful. How are you?
I'm good. Thank you. Thank you. So, where I get confused is I know you answered the question earlier as to what a plea reset is, but I'm curious to know why he did not enter a plea on June 21st at his last hearing and why the plea was reset. I get kind of confused there.
So, truthfully, we don't know for sure, right? We know that there are a couple of different, again, things that were being said. So, something that was being said was that the government expressed that he would receive 60 days prior to being sentenced, right? And if you
Right.
do the math between this
Mm-hmm.
July date and the September date, it is exactly 60 days.
Exactly.
So perhaps the 60 days he was being given prior to sentencing is being given to him now. And perhaps on September
Right.
6th, he will plead guilty and be immediately sentenced, right? That can be
Mm-hmm.
done. That's a possibility. But again, we don't know for sure. We'll have to see what happens.
Is it more likely than not, or
The
just
reason why
can't
I
say?
always say we don't know is again because you really don't. He could change his mind. On September 6th, he could say, I want a trial. So, we could never
But were
say.
those not the can were? I guess I kind of understood it to be the terms of the condition of the plea was that he had to enter into a plea
Mhm.
or accept the plea
So the
come
plea is not official.
6/21.
Yeah, so the plea is not officially entered until you enter it on the record. Now there is a plea agreement which the defendant could sign. That is true, right?
Okay.
Right. But again, that's something you would know unless you're privy to those details, right? So unless
Hmm.
you're Polight or his attorney, that's the only way you would have that paperwork. So without that paperwork, all we can say is, well, it sounds like he will plea and be sentenced on the same day. That's all the information we have.
Okay. And if you don't mind, I just have a couple more quick questions. I think they're rather quick. You had mentioned earlier, I believe, I just wanted to know, is being on the Zoom, does that equate to being in person?
So yes, court for the most
Okay.
part has come into the age of technology, right? For the most
Okay.
part, most jurisdictions will allow the defendant to appear virtually. In fact, in some cases, it has saved the government a lot of money. For some defendants who are incarcerated, they sometimes just do, the virtual from wherever the person is incarcerated, have them streaming into court. So yes, appearing virtually is acceptable in most jurisdictions.
Okay, and then my last question. Why do you think why are they just now taking his passport?
Now, this question I love. So it
Mhm.
is interesting that they are just now taking his passport. And I'm going to tell you why, in my opinion. When I have observed and stood on and represented the government in these cases in the past, the requests for passport turnover and things like that, I would make in the beginning, right? So what I've seen
Mhm.
in the past is that the request that his passport be turned over is made in the very beginning of the case. Now, here's the thing. I do not remember slash don't know if the government previously requested his passport and they just were not granted that request. Not sure. Or if maybe they are just
Mm.
for it now. So I cannot be sure on that, but I will say, yeah, it's a bit odd that that is happening just now. That is usually something that is requested to happen in the very beginning.
Interesting. Okay, well, thank you so much for answering my questions. You have a good evening.
You too. All righty. So we've got King Nile Jones. You're up next.
Can I be heard?
Yep, we can hear you and see you.
Okay, great. Thank you for doing this, first of all. My question would be, in cases, I know you can't speak to the specifics exactly, but in cases where you have say, bedroom allegations, I'll justify it that way, where they have genetic identification traces back to the defendant, what would be a reasonable justification for that happening that the defense team might possibly try to convey, if that makes sense?
I get your question and I will answer it like this. I will not say reasonable. I'm not going to say what justification would be reasonable, but I will tell you some that I have heard. And I'll tell you you know what? I'll go with the main one that I've heard. I have heard quite a bit the idea of DNA transfer. I've heard that a lot in cases that have genetic evidence. And the most prominently, we heard that at length when Nicki Minaj's brother, if you guys remember him, I don't know if you do you know what happened with Nicki Minaj's brother?
Vaguely.
Okay. So for those of you who don't know, Nicki Minaj's brother was charged with SOing his stepdaughter, who was, I think, 12 at the time. And there were some similarities between that case and this, in that a large part of that case was genetic evidence on her clothing and I believe in her underwear. His defense attorney argued that there was genetic and DNA transfer from the mom, right, which sounds similar to what we've heard, that ended up on the daughter's clothing. They argued that via the exchange of clothing between the daughter and the mother, and also via the clothing being put together in like the same dirty clothes hamper and all being washed together and melded together, that somehow there was DNA transfer from the mother's clothing to the little girl's clothing. That argument did not work.
Okay. Yeah. Sorry.
No, I was saying he was convicted. It did not work.
Okay. And lastly, I would say, I know that, and correct me if I'm wrong, Mr. Polight did receive bond, obviously. What would have been used, or what's most prominent in cases similarly to this one that would preclude him to not receive bond, if that makes sense? Because if we have the evidence that we just spoke about amongst the other allegations, what do you believe they did not have, or why was he able to receive bond, if that makes sense?
So, there's a number of things. So it's a balancing, it's a weighing, a tipping of the scales. As I said, it could have been a clerical error, right? Because that was the initial statement from many folks, was that there was an error that led to him receiving the bond. So that's the first thing. But if it wasn't a clerical error, the court could have considered a number of things. The court could have potentially considered his criminal history, because to my knowledge, he did not have a record that consists of this type of incident, right? So the court may have considered that. The court could have considered what evidence was available at that time, because I'm not sure that at the time of arrest they had the full DNA analysis yet, right? Again, could be wrong on that, but I don't think they had the full detail there yet. So there's a couple of things the court could have considered. One, past history. Two, what evidence was at hand at that time. But that's only if it was not an error, because as we've said, it could have been. And believe me, those types of clerical errors happen all the time. Defendants are released accidentally. The wrong bail or wrong bond is set because someone put a 0 in the wrong place or a 2 in the wrong place, all the time.
Okay. That makes a lot of sense. Do I have time for one more question?
Yeah, one more question, then we'll go to Claymore.
Okay, one more question. In your opinion, why does it such a large disparity amongst defendants receiving bond or not receiving bond based on the reputation or of the legal team that they have, or the representation that they can afford? Do you understand the question, so to speak?
I understand the question, and I think it matters what representation you have, right? But only to a certain extent. So I think that if you have more robust representation, especially at the early stages of a case, yes, you could increase your chances that you receive bond. I think that's true. But ultimately, even defendants with less robust representation, they would at some point in the case be released once the case continues to drag on and drag on and drag on. So could it possibly assist in someone receiving bond earlier? Potentially, if you have really robust representation. And why is that? I mean, it's simple. A judge is a person. And so what the judge is looking for is a solid argument that gives them backing for the decision that they make. So if your legal team, your representation is not making solid arguments and they give you bond, that doesn't look good for them because there's no backing there. So if you have robust representation, your representation makes a good, solid argument for you to receive a bond and be released, then the judge can say, okay, I made this decision based off of this argument.
Okay, makes sense. Sometimes it seems like robust representation is almost synonymous with financial affordability of the team that you can retain. So,
I mean, in some instances it is. But here is the thing that a lot of people don't know about criminal defense. And I saw a video yesterday of Mace, and Mace was saying all money isn't good money. And I couldn't agree with that more. So there are certain types of law like family law and criminal defense. I don't care how much money they're paying, I'm not doing it. I'm not doing it. So criminal defense attorneys deserve every dollar they get. They have stomach ulcers. They struggle with alcoholism. They struggle with drug use. They're on call 24/7. There's no Christmas. There's no weekend. There's no vacation. Why? Because guess what? People get arrested more on those days than the regular day. So yeah, money will help you have a better legal team, but they will earn every dollar. They will work for every dollar you pay them because it's akin to slavery.
yeah, well, thank you for taking my questions. Those lawyers, they chose that path in many cases. Not all, but most of them. I have to believe that, but you know better than I know. But I'll get off and thank you for taking my questions.
All righty, no problem. Claymore Jones, how are you and what's on your mind?
Hello, Esquire, can you hear me?
Yes, I can hear you.
I want to ask two questions. I remember hearing that the prosecutor said they came to a plea agreement. So does that mean that the negotiation process is over now and Polight knows what's in the plea and he's kind of accepted it but hasn't accepted it in front of the judge yet, but he does know what it is? And number two, was the mother and the alleged victim consulted about the plea agreement?
All righty, so I love that question. So if the prosecutor has represented on the record that they have reached an agreement, yes, that insinuates that there is already an agreement reached. That would mean that yes, Polight and his attorney, they know the details of that agreement. Now, the part of your question that I really loved is where you said, okay, was the victim and her mother, were they consulted? So technically, it is the right thing to do. It is the appropriate thing to do for the prosecutor to consult the alleged victim or victims before reaching a plea deal or plea agreement. That's the right thing to do, and it's considered to be the ethical thing to do. However, there is no rule written down anywhere. There is no statute written down anywhere that says that you need the approval or the review of a victim in a criminal case to take a plea deal.
Okay.
So it's one of those lines where it should happen, but it does not always happen. And sometimes, even when a victim expresses discontent, a deal could still go through.
Okay. Thank you. That's all I want to ask you. Thank you so much.
You're welcome.
Have a good one.
All right, you too. All righty. So let me address this here. So Nappy Yankee said, what? No RHOA? No, I do not watch Housewives of Atlanta. It's too ratchet. You know, I'm sorry if that, I hope I don't offend anyone, but I'm sorry. It's too ratchet. It's too ratchet. All righty. I saw somebody in here that I wanted to. Yes, here she is. Hello, Lesmeet. How are you? I am wonderful, wonderful, and I hope you are too. All right. I'm looking for questions in the chat. I don't see any questions per se, unless I missed something. If you have a question, let me know. Because if not, I'm going to head out of here. So I'm going to give you all, let's see, a minute or so. If you have any questions, plop it into the chat. Otherwise, we are going to go ahead and get on out of here. Okay, so question. If he went to trial and the DNA comes up, he might attempt a conspiracy theory on how his stuff got onto her scarf and her shirt. It seems to be a very hard sell to the jury. As I said previously, in the past, trying to argue away DNA in these cases has been a hard sell. I've seen it done. I have yet to see it be successful, right? Attorneys argue things like DNA transfer or that the lab is not as professional or impartial as they should be, or that that particular scientist cannot be trusted. They argue all sorts of things, and it isn't very often that it makes it. Next question. Are you going to comment in a video on the Nature Boy case? His wives made malicious prosecution videos naming the prosecutor, wow, and detective and discovery recordings. Huh. I'm a bit intrigued by that. I honestly haven't really touched the Nature Boy case in a while, but that's kind of interesting. Hey, Sat12, email me that stuff. Okay, let me put it again in the chat. Email me the links to all of that. I'll watch it and maybe I'll decide to do a video. All right. Rocking with the truth. Did I say hi to Diva? I don't know if I forgot to, but if I forgot to say hi to Diva, Diva Divine Light, I saw you in the chat. Love you. Hey, Rocking with the Truth. You are very, very welcome. All right. I think there's a bunch of info here. Let's see. I mean, not info, questions. Gary has an interesting question. So Gary says, what would you say to Polight if he is listening? I would say to him the same thing that I would say to any defendant in this position. Listen to your attorney. That's it. You have an attorney. You're lucky to have one that is private, right? So you should be of higher priority, if you will. Listen to your attorney. Jabari is saying that it has been said that the most serious charges have been thrown out. Interesting. Can you clearly explain how pleading guilty does not mean that? Oh, wow. So that's an interesting thing. So if a charge has been quote unquote thrown out, that would mean that charge has to be dismissed. Thus far, we haven't heard that. However, what we could hear with this plea agreement is we could hear Polight pleading guilty to a lesser charge or a lower charge on the document. And remember, the lowest charge we saw was contributing to the delinquency of a minor. There's a difference between higher charges being dismissed and a plea agreement being reached, which notes a lesser or lower charge. Those two are not necessarily the same, right? Now, what could happen due to the plea agreement is, again, he could plead guilty to the lower charge and the people could choose to dissolve of the higher charges. Okay. Let's see. I Am My Grandmother's Rebellion says, can I request? I do take requests. Can I request a reaction? She wants a reaction to the case with Shirley Strawberry's husband. Yes, you can request a reaction. I Am My Grandmother's Rebellion. Take a look in the chat and email me the info on that case. And I will definitely look into that. All right. Let's see here. All right. Sat12 said, is it possible that a plea will be made to a revision of charges, different charges we haven't seen yet? That is possible. You know, again, almost anything is possible. No, but really, that is possible. That is possible. Okay. Big Hamza says, is there a chance that Polight rejects the plea deal? Being that it's been represented that they already came to an agreement, maybe not, you know, but as I said, it's not over till it's over. You know, he can always try to implement his constitutional rights, argue that he wasn't properly informed, argue that he's being taken advantage of, and say that he wants to reject the agreement. All righty. Lucas Balchunas. Let me try it again. Lucas Balcunas. I feel like it's Balcunas, not Balchunas. All right. Oh, never mind. I mean, I guess it is nice. It's not inappropriate, right? Yeah, okay. Chief X has an admirer. All right. All right. So I do not see anything Texas Bama says, I'm a dog. Thank you. Alrighty. So I don't see any other questions in here per se. Alrighty. I think Mr. Cleanup Man is asking a question that we've kind of already answered. So you may want to take it back a bit, Mr. Cleanup Man. All right. Listen, I've been in here for almost 2 hours. Rarely do I ever do a 2 hour live. Okay. But it's been a while. So I wanted to make sure that I give you guys the time that you deserve. Right. And by you guys, I mean of all genders and all identities. Right. Please do not take that as non inclusive language. I love you. Okay. So listen, this has been another installment of Empowered Esquire podcast. I hope that you are empowered by the legal knowledge shared today. I hope you've been edified. I want you to continue to have intelligent conversations with each other, conversations that are rooted in compassion with each other. All right. Listen, I'm going to try to be around bi-weekly. It's summertime. Life is lifing, and it's so much going on. And I want to enjoy life, y'all. I do. I don't want to be trapped in the internet box, but I'll try to come on more. Okay. So listen, if no one has told you today, I love you. I mean that. And you bring something unique to this world, to my life, to my channel that no one else does. All right. See you soon.